Hello, hello, hello. Hi, everybody. Hello, welcome in. A little bit later than normal, but I've been running behind today. So, hello, Kaya, Miss Julie, John, Hitch. Good to see you. Misty Dawn, hello. Lee, good evening. Bob, hello. Cynthia, hi, welcome. Thanks for being a bit flexible with me. I'd hoped to be on about an hour ago, but things kind of changed. Great time in Australia. Okay, well, that's good to know. I'm glad to hear that. Hello, Willie B. Hello. Fancy seeing you all again. That's right. Howdy. Oh, my goodness. Hello, Janelle. Jean Marie, good to see you. Thanks for coming by. I appreciate it. Sharon, Charles, Achilles, welcome. So I was over on the TikTok briefly to take everybody through a memo that was sent to VA people. So we kind of talked about that. Oh my goodness. I will be posting that over here. I'm trying to catch up on my lives here, and so you may see quite a bit more posting over the next couple of days. Still trying to, um, get everything up and running. I think when you miss a couple of days, if you're not feeling well, then it's like, what day is it? So everything gets changed. Like, did I have a Wednesday? Is this Wednesday? He won't forget what Roberts has done. He's mad because he said, well, yeah, exactly. Well, that's the thing about Roberts, though, is that Roberts is going to do whatever's in Roberts's best interest. So if that is like, you know, being extremely friendly to Trump, then he'll do that. But if it's not, then he won't. So he can go either way. He's a swinger, uh, and typically will swing to the right. But such is how he is. I would be. What we don't want, everyone, is for the Chief Justice to step down right now. He's got a lot of years left in him, and for Trump to pick a Chief Justice, that would be truly horrific. So we want him to stay for a while at least. God help us all, right? Or the Big Bang, whatever your choice is. He went the other. Yeah, I mean, sometimes it's surprising when you're like, I didn't think he would go the other way, but sometimes they just do. From Trump to mean he was thankful for Roberts helping him get elected again. Could be. Could also be the immunity decision. So, or a mix. Could be a mix as well. Um, mm-hmm. Oh my gosh, I know. Now, Thomas may retire. Alito may retire. So we may still have that kind of a situation. But we're only, we're a month into his term, so we still have some time. Join in the join bubble will not show up on my. Oh, weird. Oh, I don't know, Cynthia. I'm not sure. Let me take a peek. I'm just now starting to try to get some benefits put into place for people who are not subscribers. Subscribing is completely free, of course, but for people who are kind of joining the different tiers. So I'm doing some research. So let me take a look. Let me write that down, Cynthia, so I don't forget. So I'm writing it here. Okay, got it. And I'll see what I can do. I'm not, I'm Gen X, so I try, but sometimes when I try, things get thrown in the backyard. So I'll do my best. Oh my gosh. Oh no. Okay, so let me write out my sticky note here. So tonight, everyone, I've got a SCOTUS decision regarding freezing federal funds, and I also have a motion for sanctions. So we've got a lot of good stuff to go through tonight. I know it's been a little time. It's been a little while since I've been here on the tube. I apologize for that. I try to not go too long. I think it said 4 days. So that's on the long side of things. I try to make sure I'm here, every couple of days at least. That's just what I'm comfortable with. Vaccine advocacy group here. So, yeah, have been on the TikTok, and I do like to do some uh, face to face over on TikTok. It's a little easier for me. And I'd hoped to come back on last night to do my closet docket, but just ran out of energy. But here I am back again in my home. I'm hoping this will be my forever home. Again, TikTok is just, I love going over and hanging out with people, but this is my final destination over here, hopefully. I pray follows the order. Well, I mean, yeah, I have no doubt that the people who can have an impact on whether or not that happens are already contemplating it. So it's out there. It's not a secret. Issue with the apps. Okay, that's interesting. Okay. Yeah, yeah. Hello, Bruce Wayne's mother. Hopefully, Bruce is doing well today. I know that's probably classified, but so we'll just keep going here. I have to say over on the TikTok that my content, I tell you what, I will post and it will go through a very long review situation before it'll actually post all the way. So I'm trying to get it downloaded so that whatever it is downloaded so I don't actually lose it. But yeah, I've had some community guidelines violations and then appealed and then they're fine, but that whole process is just like, oh my gosh, come on, man. So yeah, I think they're coming for us over there again. Seems like every couple of months they come for us and then, like yikes. We got to kind of clean all of that up again. Oh, too much. No. Oh, Thomas. No. We don't want that. Although I have to admit it was pretty overwhelming. I just took I just peeked like a solar eclipse. I would just look over a little bit and then I was like, man, I'm not going to look at it anymore. Got to preserve that mental health. Oh, thank you so much, Late Off Milkman. Oh man, the Late Off Milkman really, they took a hit with the milk. For sure. But when Trump's name came up in the warning on the day, oh yeah, I mean exactly. And I've got to make the switch. Um, I enjoy being over on TikTok, of course, and that's where I started. And I think I'm at 114,000, and that's great, and I'm happy to be there. But it's not sustainable with the amount of strikes that people are getting, and the way that they really suppress your content. So it's just we got to kind of make sure that we make sure we're in several different places here. Mike Johnson's chief of staff got a DUI last night. Yeah, I did see that. I think somebody had raised that before. Yikes! Come on, make good choices, people. Come on. Get a trick out of your backpack. Oh my gosh, John! I tell you what. For anyone who missed that story, I just did my second funny story, and it's a doozy. Oh my goodness. My I had a family member that had not heard that story before, and she was like, what? What are you doing? And I'm like, I don't know. And she, I'm like, that was your father. He did that. And she had to go in and she interrogated him. She wants to go into criminal law. And so she was like pointing her phone flashlight at his face. Tell me this again. What did you do to my mother? Oh, it was cracking me up. I had like tears running down my face. Yes, meme NATO. Exactly. So I'm not sure. I hope I've posted it. Have I posted it over here on YouTube yet? Sometimes I space out my posts on YouTube because of how the algorithm works over here. So it's probably in the queue if you haven't seen it yet. But oh my gosh. Yeah, I mean, she's not she's not playing around. She got life goals here. I don't think I could be. Oh my gosh. Yeah, I know. Same. For sure. I'd have to medicate myself somehow in order to make it through the day. So, Well, welcome in, everyone. Thanks for joining. Hello, Tay. Hello, everyone. I've got two things I'd like to get through tonight. The first is the decision from SCOTUS regarding these frozen funds, right? So we've all kind of heard about that. The decision itself by the Chief Justice is just this. This is it. And then the whole rest of the decision is Alito's dissent. And honestly, it's alarming. His rationale, his reason for dissenting, it's a little bit, yeah, it's a little alarming. So I think it's good to read through it. I don't typically spend much time on dissents or concurring because they're not law. But I think in this case, it's going to be helpful for us to see how we might be able to, predict the future a little bit. And then I have over here, as promised, for anyone who's been waiting, we have our first sanctions request off of the closet docket. So I've got two, by the way, two closet docket posts that I will be putting up here on the tube of you very soon. They're in the queue right now. So you'll be able to watch all of those if you're interested. And but we've got our first filing. So this was just a few days ago. We've got the plaintiff's motion for sanctions because of some bad faith here. And then we've got the response from the defendant. Now, keep in mind again, a lot of these filings, if yes, did anyone join Alito? Yes. So Thomas, Gorsuch, and Kavanaugh joined Alito. But when we're putting in, see, again, they're saying they acted in bad faith. But when you're listening to the defendants, the government's got a bit of a chip on its shoulder. So that professionalism, which we have come to enjoy out of the DOJ, may be tanking a bit depending on who's arguing the case, which is just really unfortunate. It's really unfortunate. They're supposed to be the leaders of the field, and right now they're compromised. So that's unfortunate. Yeah, shadow docket. I guess it's kind of like that emergency docket. I think a lot of people refer to it as a shadow docket. But yeah, this case here was like, we gotta make decisions right now, or people are gonna, die. So, and that was kind of a really big deal. The four horsemen, yes indeed, Kaya, yes indeed. And we've had that before. We've had that. Oh, thanks, so unique. I appreciate that. We've had that before, where we've had our court split in such a way that it just was excruciating. I remember a long time ago, somebody was interviewing Scalia when the court shifted so conservatively, and the interviewer said to Scalia, like, "Do you ever feel bad about the harm that you're causing to people?" And he's like, "I'm sorry, what?" Because if you know anything about Scalia's like not taking anybody's crap. And they're like, "Yeah, you're totally ruining the country." He's like, "I gotta go." So yeah, it's a trend. It happens. So here we go, everyone. We've got the Department of State versus the AIDS Vaccine Advocacy Coalition. This is a closet docket case. And just to keep everything straight, if it's on the closet, it means it's a problem because of an executive order or some kind of executive task that's been put out. So this one made it up to the U.S. Supreme Court because of the timing on it. That was really important, and the harm that could be caused. So let's go ahead and dive on in. On February 13th, the United States District Court for the District of Columbia entered a temporary restraining order enjoining the government from enforcing directive pausing disbursements of foreign development assistance funds. So that's the frozen federal funds, said in a bougie way, I guess. The present application does not challenge the government's obligation to follow that order. On February 25th, the district court ordered the government to issue payments for a portion of the paused disbursements, just a portion, those owed for work already completed. So this is work that's already been done, right? And who remembers that whether or not Mr. Trump likes to play or pay out people that have already done work for him, right? So I don't think we're surprised here. Right, so work already completed before the issuance of the district court's temporary restraining order by 11:59 p.m. February 26th. So we got to watch our dates here. Several hours before that deadline, the government filed this application to vacate the district court's February 25 order and requested an immediate administrative stay. The Chief Justice entered an administrative stay shortly before 11:59 p.m. deadline and subsequently referred the application to the court. The application is denied. So we're kind of flipped around a little bit on who the defendant and the plaintiff is. So what's being denied is the government's request is being denied. Given that the deadline in the challenged order has now passed, and in light of the ongoing preliminary injunction proceedings, the district court should clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order with due regard for the feasibility of any compliance timelines. The order heretofore entered by the Chief Justice is vacated. So the Chief Justice had said before, we're not going to have the restraining order in place. All right. He had reversed the lower court's restraining order. And then now he is saying, I'm revoking my reversal. And so the lower court's order is good to go, but I want you to clarify, exactly what we're dealing with here. So that was it. This is the order. All right. That's it. Because when we flip the page, now we're in the dissent. And this dissent is scathing. And quite frankly, it's a bit frightening. Oh, thank you, John. Oh, thank you so much. I love that. Let's see, a walk-in house closet. Oh my gosh. Yeah, it's gonna be a lot. It's gonna be a lot. it's gonna be. Yikes. Yeah, my closet. I don't know what I'm gonna do, everybody. There's a lot going on right now. All right, so let's take a look at the dissent, everyone, which is the bulk of what this decision is. The dissent was written by Justice Alito, and let me just show you who that is off of my chart. This is Justice Alito here. He's the third with seniority. Sorry, he's the second. It goes Thomas, Alito, then Sotomayor, I believe. I may have Sotomayor and Alito mixed up, but so this is Alito here. Now on the dissent, of course, Thomas joined him because he's a bad man. And then Gorsuch and Kavanaugh also joined. All right. So, oh my gosh. So the other justices were like, no, but those were the ones on the dissent. So we have several pages of the dissent. I think it will give us some good insight into where Alito's coming from here. Yeah. So, that was for a different... I was taking notes during one of the oral arguments and I couldn't help myself. I was pointing at each justice as they were talking. And I was like, this one needs some horns. So here we go. Justice Alito, with whom Justice Thomas, Justice Gorsuch, and Justice Kavanaugh join, dissenting from the denial of the application to vacate the order. So keep in mind here, the order was to have no temporary restraining order. Okay, that was the order. And that's been vacated now by the Chief Justice. So kind of keep that in order. It gets a little confusing here. Here we go. Does a single district court judge who likely lacks jurisdiction, have the unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? So this right here is like, I'm sorry, what? That's not right. The answer to that question should be an emphatic no, but a majority of this court apparently thinks otherwise. Otherwise, I am stunned. So I'm not stunned that you're stunned because you're a crazy man. Yeah, so he's upset about this. Now, this isn't the first time that judges... oh, thank you so much. I appreciate that, Cocoa Latte. This is the first time that Supreme Court judges go after lower judges. So let's keep that in mind here. Calling out a lower judge isn't unusual, but let's keep going and seeing what he has to say. In capsule form, this is what happened. Respondents are a group of American businesses and nonprofits that receive foreign assistance funds from the State Department and the U.S. Agency for International Development, so the USAID, right? They brought suit and claimed that the current administration's temporary pause of foreign assistance payments is unlawful. On February 13th, the district court issued a temporary restraining order requiring the government to halt its funding pause. it based that decision on a finding that respondents are likely to succeed in showing that the government violated the Administrative Procedure Act. After issuing the TRO, the district judge grew frustrated with the pace at which funds were being dispersed, because they weren't being dispersed. And on February 25th, he issued a second order requiring the government to pay out approximately $2 billion. The judge brushed aside the government's argument that sovereign immunity barred this enforcement order. So this sovereign immunity baloney is going to be, apparently the hill that Alito's willing to die on. The sovereign immunity crap. He's gonna be bringing this up over and over and over again. So we've got federal versus state as one level, and then we have the 3 separate branches as another level. So again, this term sovereign immunity is going to be one of his issues. So sovereign immunity barred this enforcement order, and he took 2 steps that, unless corrected, would prevent any higher court from reviewing and possibly stopping the payments. First, he labeled the order as a non-appealable restraining order, and second, he demanded that the money be paid within 36 hours. All right, so these are the things that have upset him. He said, you can't pull the restraining order, and I'm going to give you 36 hours, which is more time than what they gave people working at Veterans Affairs. They gave notice of with that. So don't get me started on 36 hours. This left the government little time to try to obtain some review of what it regarded as a lawless order. The government moved for a stay pending appeal in the district court, but the judge shrugged off the government's sovereign immunity argument, as I'm doing right now. This is how you shrug it off. You say, that's stupid. And ignored the government's representation that most of the money in question, once dispersed, could probably not be recovered. The government quickly filed an appeal in the United States Court of Appeals for the District of Columbia, but within only 4 hours to spare before the payment deadline, the DC Circuit dismissed the government's appeal because it took the district court's TRO label at face value and determined it lacked appellate jurisdiction. So what they're saying here is that the Court of Appeals said, nope, we're good to go, lower court's fine. With nowhere else to turn and the deadline fast approaching, the government asked this court to intervene. At the last moment, the Chief Justice issued an administrative stay. Unfortunately, a majority has now undone that stay. There's definitely some fights going on the bench there, everyone, like pretty significant. As a result, the government must apparently pay the $2 billion post haste, not because the law requires it, but simply because a district judge ordered it. As the nation's highest court, we have a duty to ensure that the power entrusted to federal judges by the Constitution is not abused. Today, the court fails to carry out that responsibility. That's such crap. I've got no sympathy. Yeah, he's really admonishing. Yeah, he's upset. He's really upset about this situation. I think, my guess, and again, I haven't read through all of it, and we'll keep going here. My guess is that he's upset that the district court said that the restraining order wasn't appealable. I bet you that's what got him all upset, because he's trying to say that a district court judge is pulling power away from the Supreme Court, and how dare you? So I think that's what he's all upset about. All right, number 2, time does not allow a lengthy discussion, but he's going to still do it, of the legal issues presented by this case. But a brief summary suffices to show that the district court's order should be vacated, or at the very least, stayed. To start, it's clear the district court's enforcement order should be construed as an appealable preliminary injunction, not a mere temporary restraining order. A restraining order, as its name suggests, is temporary, and its proper role is to restrain challenged conduct for a short period of time while the court considers whether more lasting relief is warranted. The order here, which commanded the payment of a vast sum that is in all likelihood can never be fully equitable. Oops, sorry. Can never be fully, my page is flipped here. Wait, what happened? Sorry, there we go. Recovered is in no sense temporary, nor did the order merely restrain the government's challenged action in order to preserve the status quo. Citing case law. Rather, it acts as a mandatory injunction requiring affirmative action by the government. And given its likely irreversibility, the district court's enforcement order effectively gave respondents a portion of the ultimate relief they seek. Because they're saying, again, this district court is saying you should pay for the work that's already been done. They're not saying, all the money. They're just saying, at least let's pay for what's been done already, and then we'll sort the rest out. For these reasons, the Court of Appeals had jurisdiction to consider the government's appeal. Now, again, the Court of Appeals said they did not. And we have jurisdiction to review and summarily vacate that court's erroneous judgment. So he's like trying to take a power grab here. I think he's just upset because this judge was like, you guys can't pull this crap in here. By not paying it. Well, exactly, Jennifer. Exactly. All right. He's moody. Well, yeah. It might be the menopause. It might be. Number 3. Oh my gosh. Number 3. Even if the majority is unwilling to vacate the district court's order, it should at least stay the district court's enforcement order until the government's able to petition for a writ of certiorari. In considering whether to issue such a stay, we ask at minimum, number 1, whether the moving party is likely to prevail on the merits, and 2, whether that moving party is likely to suffer irreparable harm. You're very hormonal. Yes, I agree. Emotional. That's funny. And I don't mean to say, by the way, that's not a dig on menopausal women. If you've got a guy going through menopause, he's in bad shape because he doesn't know how to deal with what women have to deal with all the time. So let me just clarify that. Now, reciting case law here, in close cases, we also take into account other, and we'll flip the page, equitable considerations. Now, I want to hop back and catch this footnote here. Right. So, where's our footnote? We missed it. I missed it. I usually catch those pretty easily here, but for some reason I've missed this one. It's not a footnote. It's a star. Come on, Alito. Where's your professionalism? Really? Come on. All right. Here we go. I lost my eye while rolling. That's so funny. All right, here's our footnote, which isn't numbered. It's just a star. To the extent that likelihood of certiorari is a relevant factor, here he's citing Justice Barrett case concurring in the denial application for injunctive relief. It is met here. Recent years have seen a sharp increase in district court orders enjoining important government initiatives, and some of these have been labeled as unappealable TROs. And he's citing the Dillinger case. Whoa. Okay, so the Dillinger case is one where this is the other case on the closet docket that's made it to SCOTUS. All right, this is the one where the special counsel was pulled apart, and this guy who had been appointed to the position had been terminated. This case went up to the U.S. Supreme Court. The lower courts had said, you need to put him back. And the U.S. Supreme Court said, we're not even going to hear this case. So I think Alito's kind of pissed off about that too. I think that might be an issue. So that's this case. That was just up in front of the Supreme Court like a few days ago. And they said, we're not going to hear it. Clarification of the standards for distinguishing between a temporary restraining order and a preliminary injunction is a matter that deserves this court's attention at the present time. The same is true regarding the scope of the APA's waiver of sovereign immunity. Yes, exactly. Those are the vibes. Don't say this cheetah. Like Hitch, yes. citing Dillinger could be fired for now. All right, well, there we go. Things are moving. Here we go. Let's get back into it here. We got our footnote out of the way. Our unnumbered footnotes. Disappointing, Alito. Here, these factors weigh in favor of a stay. Sorry, everyone. Here we go. The likelihood of success. This is one of the factors. The government has shown a likelihood of success on the merits of its argument that sovereign immunity deprived the district court of jurisdiction to enter its enforcement order. Sovereign immunity bars a suit by private parties seeking to impose a liability which must be paid from public funds in the Treasury, citing the Edelman case. I think this is, again, the hill that Alito is going to be on. But that's exactly what the district court ordered here. Here we've got quotes, the restrained defendant shall pay all invoices and letter of credit, drawn down requests on all contracts for work completed prior to the entry of the court's restraining order on February 13th. Sovereign immunity may be waived, but to sustain a claim that the government's liable for awards of monetary damages, the waiver of sovereign immunity must extend unambiguously to such monetary claims. Attempting to satisfy this strict requirement, respondents point to the APA's waiver of sovereign immunity for certain actions. Here, certain actions seeking relief other than money damages. That language, as we have explained, distinguishes between specific relief, which is permitted under the APA, and compensatory or substitute relief, which is not. Again, each one of these cases, I think, is going to be critical when we're working through these cases with the Supreme Court. The sovereign immunity crap is what is going to get Alito all up in arms. And so here, but the relief here is more closely resembles a compensatory money judgment rather than an order for specific relief that might have been available in equity. I don't know, that's a stretch. Citing case law, an injunction to compel the payment of money past due under a contract or a specific performance of a past due monetary obligation was not typically available in equity. So again, the key word here would be typically. Sovereign immunity thus appears to bar the sort of compensatory relief that the district court ordered here. Hoping to escape that conclusion, respondents point to the Bowen case. In that case, we held that the APA's waiver of sovereign immunity covered a district court judgments reversing a final order of the Secretary of Health and Human Services refusing to reimburse Massachusetts for certain Medicaid expenditures. Unlike the district court's order here, the judgment did not purport to order that any payment be made by the United States. Rather, Bowen simply recognized a basic reality of the APA review. After a court sets aside an agency's action, a natural consequence may be the release of funds to the plaintiff down the road. And we have since clarified that Bowen has no bearing on the availability of an injunction to enforce a contractual obligation to pay money past due. This sort of relief that appears to have been ordered here. This is really interesting, an interesting argument also, because it seems like we've got this waiver, this discussion on the Administrative Procedure Act that he's saying we've got, we need to clarify this issue. These guys sure have their bloomers in a bow. Oh my goodness, they certainly do. They certainly do. The district court, however, failed to mention, much less reckon with, Bowen or Knudsen before plowing ahead with its $2 billion order. Nor did it take account of our previous suggestion that the proper remedy for an agency's recalcitrant failure to pay out may be to seek specific sums already calculated and past due in the Court of Federal Claims. I'm wondering too, just to think about, and I never would have said this before with the Supreme Court, but I'm wondering how much a discussion is going on between the justices and Trump. Wasn't there a phone call didn't Trump have a phone call with Alito at some point? is one question. And I'm wondering how much of a heads up they're actually getting from the Supreme Court. So he could just say, tell your lawyers sovereign immunity. And, they come back with these different arguments. Yeah, it rings a bell. Yeah, doesn't it? I mean, uh, giving a little bit of insight into that when he hired his lackey. Oh my gosh, that's right. Yikes, the lackey. So we kind of got to keep that in mind, honestly, that it seems like everything is being set up in order for Alito to make this proper argument here. So we've got a quote from the Bowen case invoking the First Circuit's suggestion that if an agency persists in withholding reimbursement for reasons inconsistent with our decision, under the APA, the remedy would be a suit for money past due under the Tucker Act in the claims court. The most that can be said is that in district court's denial of the government's motion for a stay pending appeal, it cited but did not analyze a handful of cases echoing Bowen's discussion of the APA's conscribed waiver of sovereign immunity. One might expect more care from a federal court before it so blithely discards a sovereign dignity. So apparently he's taking that as a personal attack on him from this judge, because he thinks he's just that important to everybody. Is it normal for the dissent to be 10 times longer than the order? No, it is not. It most certainly is not normal. It happens, but it's the exception. It's not the rule. Oh, that's so funny. Yeah. Basically, he wants a civil suit instead. Yeah, he's like, you should go and, basically he's saying this should be small claims issue rather than, an issue here for this court. And personally offended with the sovereignty being brushed aside. Finally, the government has a strong argument that the district court's order violates the principle that a federal court may not issue an equitable remedy that is more burdensome to the defendant than necessary to redress the plaintiff's injuries. And we're citing the Califano case, which is actually a really important case regarding this immunity question and injuries. In this case, the district court's enforcement of other functions as a universal injunction defying these foundational limits of equitable jurisdiction, citing the Labrador case, where Gorsuch was concurring in the grant of the stay. The district court ordered the government to pay all invoices and letter of credit drawdown request on all contracts for pre-restraining order work completed. Again, it's like, what, you don't want them to pay what they already owe? Like, right? That's why we couldn't have any student loan breaks, right? Like, you should pay what you owe. Like, what? Except for if it's a contract you made with other people, right? That order encompasses more than just respondents, and the district court offered no reason why universal relief to non-parties is appropriate here. And this is not the sort of case in which only universal relief is feasible. Even supposing the APA allows universal vacatur of rules in some circumstances, the district court's order of direct monetary payment bears no resemblance to that. All right, we're citing a case now with Kavanaugh. So Gorsuch has been in, Kavanaugh's been in, respecting denial of application for stay. And nobody has suggested that the government's unable to identify respondents as allegedly owed funds. Allegedly owed? Harsh. That's harsh, Alito. And pay out only to them. Limiting the scope of relief in that manner would be significant. Below, the government represented respondents seeking roughly $250 million. Still a large figure, but a fraction of the $2 billion ordered. Emergency motion for immediate administration of stay is where he's getting that from. Here. Harm to the parties. So here's factor number 2. The government has shown that it's likely to suffer irreparable harm if the district court's order is not stayed. The government has represented that it would probably be unable to recover much of the money after it is paid because it would be quickly spent by the recipients or dispersed to third parties. So they're saying, if you make us actually pay our bills, then we're not going to be able to get that money back. All right. Respondents did not credibly dispute this representation. Wow. So they disputed it, but it wasn't credibly disputed. And the district court did not find that it is incorrect. we usually balance the equities and weigh the relative harms in close cases. For the reasons I've explained, this is not such a case, and our analysis could end there. Nevertheless, respondents' equitable arguments are insufficient to justify the denial of a stay. They contend that the failure to pay the money in question would cause them irreparable harm because without those funds, they could not continue to operate or would have to reduce the work they do. As a result, they claim recipients of their services would suffer. I think like they're trying to pull all services, so I don't think there are any recipients, but whatever. These potential consequences are, of course, serious, but any harm resulting from the failure to pay amounts that the law requires would have been diminished, if not eliminated, if the Court of Appeals had promptly decided the merits of the government's appeal, which it should not have dismissed. So again, he's upset about this. He's saying the Court of Appeals should have done more. Meanwhile, he reversed the Court of Appeals on so many things when it comes to Trump that they're like, forget about it. Here we go. If we sent this case back to the Court of Appeals, it could still render a prompt decision. If it decided in favor of respondents, the government will be obliged to pay all the money that's due, and respondents would have suffered only a short delay in the receipt of payments. And if the government prevailed on its sovereign immunity arguments, neither respondents nor any of the recipients of their services would have suffered any unlawful consequences. In sum, the factors we consider in deciding whether to issue a stay weigh strongly in favor of granting that relief. Today, the court makes a most unfortunate misstep that rewards an act of judicial hubris. Come on, Alito, come on. And imposes a $2 billion penalty on American taxpayers. That money was already supposed to be paid out. Dude, that's really... The district court has made plain its frustration with the government, and respondents raised serious concerns about non-payment for completed work, but the relief ordered is quite simply too extreme a response. You mean to pay what you're supposed to pay? Federal court has many tools to address a party's supposed rude, nonfeasance, self-aggrandizement of its jurisdiction is not one of them. I would chart a different path than the court does today, so I must respectfully dissent. Not a lot of respect there, Alito. So, there's that. Okay, so there's the decision. And again, to just review, this is the majority opinion right here. All of those other pages was the dissent because Alito was all upset. Have to just do it right. I know, right? He's pissed about jurisdiction. Exactly right. So he's upset about jurisdiction. He thinks the Court of Appeals should have done things differently. The district court shouldn't have put limitations on the restraining order and all that jazz. Yeah, and all that jazz. Yeah, he's salty. That's funny. Oh, all right. So that's the first order for tonight. Let's go ahead and dive in while I still have some voice left. I'm going to kind of skip through this one, but we have a request for sanctions. Again, I will read through the intro in the background here, and then we'll hop over and see what the response is on this one. So, do we need a sticky note for this one, everyone? Just let me know. Judicial branches are totally overriding the legislative. Congress spent that money. Oh my gosh, yeah. I mean, to even take it back one more step, yeah, they absolutely are. It's a problem. It's a significant problem. It is crazy. I think crazy is the correct descriptive word for it. So, oh my God. I tell you what, I'm going to have to tell you my cornflake story sometime, everyone. All right. I'll do a quick little sticky note that just says motion for sanctions. So I don't forget. Oh my gosh, and my stacks of paperwork here that my husband's having nightmares about. Sanctions. Here we go. All right. Next up. Next up, we've got Jane Doe's 1 through 7 versus Office of Personnel Management. Civil action here, again on the closet docket. It's another one. And we've got a motion for sanctions. So let's go through what the motion's about and the background. Plaintiff's motion for sanctions, and then we have footnote number 1 down here. And as we've all learned, the footnotes are really important because plaintiffs are filing the version of this motion that they served on defendant's counsel on February 23rd in accordance with Federal Rule of Civil Procedure 11C2. It's not fully up to date. This motion is bolstered by subsequent factual developments. So they're saying, hey, we filed this, but there's more stuff we could add, which plaintiffs will discuss in greater detail in their reply, meaning after the defendants put in their opposition, the reply will include the new information. Additionally, some of the characterizations of the defendant's counsel statements in previous hearings may not be 100% accurate due to the fact that plaintiffs did not have the transcripts at the time, and plaintiffs will identify any necessary corrections in the reply as well unless the court requests an earlier notice. None of the discrepancies should change the course analysis, however. This footnote and the necessary repagination and renumbering, that's such a great word, I love that word so much, of subsequent footnotes and the filing date are the only modifications made to this filed version, except for the correction of 2 minor typographical errors. So they're just clearing this up, saying this is exactly what we sent to the defendants, although there is more information, we'll add them later. That's kind of a point of clarity. All right, here we go. Are we ready? I think we're ready. I'm gonna need to take a... All right, here we go. In a bid to avoid a temporary restraining order, TRO, for failing to conduct and publish a privacy impact assessment for the computer system, which would later be referred to as the government-wide email system, or GWES. I'm just going to call it GWES rather than GWES. Defendant Office of Personnel Management published a document at the last minute, which, while purporting to be a PIA for that system, was both factually inaccurate and legally insufficient. OPM entitled this document Privacy Impact Assessment for Government-Wide Email System. Here, footnote number 2, let's hop down. Plaintiffs refer to this document as PIA simply for convenience. They do not concede that this document is in any way a legitimate PIA required by law. That makes things confusing. And published it for pretextual reasons for the purpose of misleading this court and arguing that its publication renders the case moot, just as the government rescinded an Office of Management and Budget memo for similarly pretextual reasons in the National Council of Nonprofits. It appears that the OMB sought to overcome judicially imposed obstacles without actually ceasing the challenged conduct. The court can think of few things more disingenuous, end quote. Because the court's already familiar with the facts surrounding the GWES PIA and plaintiff's allegations regarding its inaccuracy and legal insufficiency, plaintiffs will not belabor the issue further herein, and they will solely focus on the new developments which have led to this motion for sanctions being filed here. Simply put, OPM and its counsel offered false evidence in the form of an alleged PIA, which made patently false statements about the GWES, and then proceeded to argue this court should deny plaintiff's restraining order motion based on the assertion that those false statements were true. Yeah, you can't put false statements in, all right? I mean, Mr. Trump kind of got away with a lot of that crap when he was doing his criminal cases, but like we're in the major leagues now, so you can't be playing that crap here. These attorneys are going to call you out on that. Furthermore, OPM and its counsel heavily implied that the information about individuals who were not executive branch employees have been purged from the system when it was discovered, which also turns out to be patently false. Both of these actions demonstrate a clear lack of candor to the tribunal, and OPM and its counsel should be sanctioned for unreasonably multiplying the proceedings and violating the integrity of the court's process by entering statements into evidence which were known to be false and then citing them uncritically to the court. to convince the court that OPM's actions were legal and that plaintiffs were not at risk of imminent harm. So this is pretty major. That's a pretty major accusation here. Now, let me just peek. I'm going to kind of fast forward here. We have some idea then of what they're claiming was the harm that was being done. And then they're asking for monetary and equitable sanctions back here. I think that's important. Excuse me. So with that, now we have an idea. They're saying false evidence, false information was given to the tribunal. Now let's see what the defendants have to say about that. So here is the defendant's opposition to plaintiff's motion for sanctions. Again, these were just filed a couple of days ago. So here we go. This is a response directly to what we just read through. Defendant's opposition here, the Office of Personnel Management and undersigned counsel hereby respond to plaintiff's motion for sanctions. For the reasons that follow, the motion should be denied. I wonder how many times they've actually had to do an opposition to sanctions. I mean, seriously, I wonder how many times this particular government agency has bad faith arguments put up against them. I don't know, or they don't know. Introduction. Without a single citation to a transcript, plaintiffs recklessly and falsely accuse undersigned counsel of having acted in bad faith in opposing plaintiff's renewed motion for a temporary restraining order. The crux of plaintiff's accusation is that defendant submitted to the court a false document and argued that the court should rely on statements made in the document. But nothing could be further from the truth. Really, nothing could be further from the truth. I'm sensing Stephen Miller, everyone. Defendant's counsel never vouched for the substantive accuracy of the privacy impact statement. You did not just say that. Are you frippin' kidding me? Come on. All right, we got to go backwards. Just a minute. What did you just say in a legal document? Oh my gosh. Defendant's counsel never vouched for the substantive accuracy of the privacy impact statement. Come on. It's submitted in connection with its opposition to plaintiff's motion for a TRO. To the contrary, defendant argued that it was not required to prepare a PIA, that it did so anyway, that the published PIA contained the required statutory elements set forth in Section 208 of the E-Government Act and the Administrative Procedure Act, did not permit a challenge, oh my gosh, I know, the PIA, to the substance and accuracy of the PIA because the PIA did not constitute final agency action. Plaintiff's purported evidence of sanctionable conduct consists of nothing more than one, a rehash of their argument that the PIA's accuracy is challengeable under the APA, which is an argument this court declined to reach at the TRO stage because plaintiffs have not shown that they likely have standing to sue. And two, misrepresentations of defendants' arguments and statements, all without citations to the transcript. Now, remember that very first footnote, the plaintiffs in here said, we don't have the transcripts. That's why we can't cite to it, which, there you go. This motion should be swiftly and sternly denied. So let's bump down and see what our footnote says here. This court's court reporter was able to produce transcripts in 2 hours times. Plaintiff's counsel either could not be bothered to order transcripts before making unsupported statements accusing OPM's counsel of bad faith, or worse, he ordered the transcripts and finding no support, declined to include them. Whoa. This is an ethical violation. If you don't have any support, you can't just be swinging stuff around and saying that an attorney intentionally was declining to use information that could exonerate the person they're accusing. You can't just be doing that. That's a big deal. I'd say that's definitely an ethics question. All right, then we've got our legal standard. We'll just kind of push through here. Legal standard argument. Plaintiffs present no evidence of sanctionable conduct. So let's just hit kind of like the first piece of this one. The argument section of plaintiff's motion consists of 2 pages reciting case law on sanction standards. And with one sentence conclusion, OPM and its counsel, here we go, intentionally, unreasonably, vexatiously, and in bad faith entered a document containing false information into evidence and argued that the court should rely on the statement made in that document. Plaintiffs are very wrong in every respect. All right, so again, I'm just kind of zipping through this a little bit because basically they're just saying no. The sanctions are against the government. They're claiming that false information was given to the court, was created by the government in order to get out of trouble for not complying with the rules. And, then when they did create it, it was false information. All right, so let's go to the final paragraph here. A vindictive and meritless motion for sanctions against opposing counsel is no way to relitigate what in reality is a second bite at arguments already made in plaintiff's unsuccessful TRO motion. Plaintiffs are free to argue on the merits, if they can get there, that the PIA constitutes a final agency action subject to the APA review, or that OPM should be required to amend its PIA, which it has recently done despite not being required to have a PIA in the first place. And then footnote 4 here. We're a bit snarky here. Number 4, updated the PIA February 28th. The latest version of the document can be found here. All right, but that does not exclude plaintiff's counsel's conduct in filing a frivolous motion in impinging on the reputation of OPM's counsel without even taking the care to check his allegations against the official transcript. Undersigned counsel in this court deserves better. So, right, and then what happened was plaintiffs said, just you wait, we've got a reply brief coming in. So they've got one more written brief or written motion to add to combat what the defendants are claiming here. So the defendants are saying, they're basically saying like, nuh-uh, we didn't do that. We didn't do that. Everything we did was fine. And we have no obligation that anything needs to be accurate. we just did what we were told to do, right? So, oh my gosh. So now the plaintiffs should be submitting at any time. We should get their reply to see what's going to happen. Now, when we've got sanctions like this, it's basically, they're going to argue it out. A hearing is usually set up. So the judge will say, fine, let's hear this in court. If the judge doesn't want to just make a ruling from the bench, like the judge has a pretty good idea of what's going on here. So it's possible the judge may say, no sanctions. We don't need that. We're going to just put everything on pause because we don't have specific outlined requests for oral arguments here. So I don't think that would be completely required. Again, here we've got respectfully submitted. So it's possible the judge could rule from the bench, but it'd probably be better for the record to make sure you're making a record so you'd have a hearing. After the reply brief comes in, then the judge will assess at that point and decide whether or not they want to do a hearing. And then we'll have our final answer. But that's a pretty significant claim, everybody. If you're saying that opposing counsel created evidence and the evidence was misinformation and then filed it with the court, that's pretty big. That's a pretty big issue. So you could get in a lot of trouble for doing that. All right, so that's it, everyone, for the documents that I've got tonight. I think we covered covered a lot of ground when we were going through and discussing the issues here. I do have, again, just to remind everybody, I did go through that VA memo email and on TikTok before I came over here, and I will be posting that live as soon as I can. Right, Ethan, so what we've got are sanctions being requested in one of our cases against the administration here. They're saying false information was created and filed. Catching us up on everything. Oh, absolutely, everybody, absolutely. So again, I will be back over here as much as I possibly can be. I've been kind of out for a couple of days, but I am making a comeback. I've got lots of posts. Anything that I post now on TikTok, I'm making sure to post over here. So you shouldn't be missing any posts. It's just the amount of time. Like in TikTok, I can post every 30 minutes, but over here, I've got to wait. I've got to kind of space them out a little bit. So it takes a little bit of time. But all of that information is over here, and as well as the lives that will be posted as well. So I'll keep you all up to date as best as I can. Um, I'm definitely feeling better, Carol. Oh my gosh, what is that? Is that a cheeseburger? Oh no, it's a little dab dude. Oh my gosh, I thought that was toast. I was thinking like, look at that buttered toast. Oh my gosh, I love that so much. That's like my new favorite thing ever. You're the best. Oh, thank you so much. Oh, I appreciate that. I appreciate that so much. I'll be staying on top of it, everyone. Sometimes it's kind of slow going, but we'll get there. We'll get there, one foot in front of the other. I'm so glad. I'm so glad. Could be a cheeseburger. I know, right? Now my stomach's like, let's have cheeseburgers. So with that, my friends, I will go ahead and sign off for now. I will be back again very soon. I am hungry, John. I know. My stomach's growling now. Don't listen. Don't listen. But I apologize. It took a little extra time to get here. But again, I do like to come and do a live, at least every couple of days. This time was a little bit too long for me. So I'll be back again pretty soon and try to do a post to give you some idea of when I will be back up and running. So, thank you so much, Alice. I appreciate that. Have a good night, everybody. Hang in there. We're all in this together. I'm keeping my eyes out, and I will keep you updated on what's going on.